Hello, it's Phillip Taylor speaking from Richmond Green Chambers, and this morning I'm looking at a book from Elgar Publishing. It's International Investment Law and Soft Law, and it's edited by Andrea Bjorklund and August Reinisch. I hope I pronounced those names correctly. Both authors are very distinguished professors, and this is an excellent book. We've given it the title Erudite International Debate on a Timely Topic, which is international investment law, of course. This is the book here. It's only a small book, very much part of the stable of books from Elgar, which is a family business in international publishing. That's the spine, and there's the back. The actual painting at the front is done by Professor Reinisch himself, and it's mentioned, in fact, on the back. You can see that a little bit there. Now, the book itself is very much what you'd expect. There is a very detailed index at the back. You've got a lot of reference material. You've got substantial, copious footnoting at the bottom there. And you've got headings. You do have a certain amount of paragraph numbering. Not very much, but enough, I think. It's a very detailed book, and it's obviously got a lot of work has gone into it itself. Those are the contents, so you can see what areas are covered, and you can see the various list of contributors, because it's not just a couple of people, it's quite a large number. Do read the introduction, which I think is also very helpful as well. Let me explain what we've said about the book, which is on the web and in the journals. As the learned authors have expressed it, this book from Elgar has brought together a group of 9 distinguished contributors from some of the world's top universities and academic institutions to discuss the intersection of soft law and the law of international investment. So what they've done is they've been able to produce an international perspective on the topic, and the various contributors that we have actually in presenting the work in the book itself have been members of a study group that has concluded its work with the publication of the Oxford Handbook on International Investment Law itself, and that addressed major issues relating both to substantive and procedural investment law. As explained by several of the contributors, including Moshe Hirsch, who writes the second chapter, soft law rules are not legally binding, and it's up to the discretion of legal decision makers as to whether or not such rules can be applied to a particular dispute or not. His chapter in particular briefly discusses, amongst other topics, the interactions between soft law, which are non-binding instruments, and the recognised sources of investment law itself. Now, obviously there is a debate jurisprudentially about what soft law really means, but I think you get the general idea. The views of this group of international experts do shed interesting light on such matters as the GATT, WTO, and certain fields in particular, namely commercial law, environment law, as well as investment law itself. So fundamentally, the various chapters attempt to answer the general question of whether investment law can or should be codified, with special reference to such issues as most favoured nation treatment and also expropriation. Can I say that I would expect eventually everything will be codified? We've been moving towards that for quite a long time now, but it's going to take a while. As I've indicated, it's extensively footnoted, this work, so if you're involved in investment law or government investment treaty negotiations, or arbitration proceedings in fact, or if you've got any general interest in international law and legal theory, we think you do well to acquire this book. It is an academic book primarily, but it's excellent, I think, for those involved in detailed practice. Thank you very much. Bye-bye.